Welcome to Huddleston Bolen. Today we'll be featuring Scott Sheets, a partner in the firm's Huntington, West Virginia office. Scott's practice is focused on employment law and labor management relations. The focus of today's presentation is retaliatory discharge.
Retaliatory discharge is a type of civil action that employers need to be aware of. Many times employers are faced with complaints brought under the Human Rights Act, which involve complaints of race, sex, age, disability, religious discrimination. What happens when you have an employee who can't fit within the parameters of the Human Rights Act and feels that he or she was wronged by your termination? What happens is that employee starts looking for another cause of action to bring against you, and the most likely form of cause of action is one for retaliatory discharge. Retaliatory discharge or wrongful termination is an exception to West Virginia's at-will employment status. Basically, it says that if you have violated some substantial public policy of the state, then irrespective of the fact that West Virginia is an at-will employment state and you have the right to terminate someone, that is tempered by your violation of the substantial public policy of the state, and the employee is entitled to sue for damages. This has been around for a long time, since 1978 with the case of Harless versus First National Bank of Fairmont. It has been modified several times since. But what I've seen recently is that employees, lawyers are becoming creative in their lawyering, and they're finding ways to create substantial public policies for the state and then claiming that you breached them when you fired their client. Let me share some of the examples that I've encountered where plaintiffs' lawyers have attempted to be creative in creating state substantial public policies on which to base these cases. Recently I had a case where the employee was fired after complaining to HR, and she claimed that that was a public policy that ought to be protected, her right to complain to HR. In fact, the employee had a long record of absenteeism, and that was the reason for her termination. However, she was able to get the judge to believe that merely making a complaint to the Human Resources Department was sufficient to establish a state's substantial public policy. The real danger with these cases is that the court makes the first decision as to whether or not a state's substantial public policy is at issue. And you won't get to contest that after the court makes that ruling unless you litigate the full thing through trial and then take it up on appeal to the state Supreme Court. I've had plaintiffs' attorneys tell me that their real goal in filing these retaliatory discharge cases is simply to get past the judge. In other words, get the judge to buy the idea that whatever public policy they're claiming is at issue is really a substantial public policy. Because once that occurs, then you're faced with really no good choice. You can either go to trial, and if you lose, attempt an appeal with the state Supreme Court, or you settle the case. But either way, the plaintiff's counsel has got the hook in you, and you're now stuck with not getting it dismissed outright by the court. So be aware of these retaliatory discharge cases, and be aware of what you really need to do anytime you terminate an employee, and that is make sure that you have legitimate, valid reasons for the termination. Look to see whether this particular employee has ever complained to Human Resources about anything, and if he or she has complained, be aware that a creative plaintiff's lawyer might attempt to turn those complaints into some sort of substantial public policy that's being violated by their termination.
Thank you for joining us for this informative video. Please don't hesitate to contact us at Huddleston Bolen for more information or to discuss your legal needs.